Good morning or good afternoon, everyone. Welcome to this webinar dedicated to CETA and e-commerce. I'm Delphine Adenau-Ousu, the Executive Director of UCAN. The EU Chamber of Commerce in Canada is a key resource and main point of contact for EU businesses in Canada or for EU businesses seeking to enter the Canadian market. So feel free to contact us if you have any question related to your Canadian project. We advocate for EU companies. We inform EU and Canadian companies about CETA. And since January, we open our membership to corporate companies. You will have a great opportunities to participate in industry committees and network. So if you are interested, feel free to contact me and I will drop later in the chat box also some information. I also want to remind you that on our website, you have a lot of resources regarding CETA and general information regarding Canada and EU trade relations. Now, it's time to dive into chapter 16 of CETA, which is dedicated to e-commerce. And I would like to introduce the three speakers of today's session. So first of all, we'll have Eugene. He's the former national chair of the firm's Intellectual Property and Information Technology Group. We have Myron. He's a corporate lawyer with significant experience in the technology sector. And we also have Peter, who is an associate in Miller Thomson Intellectual Property Group. So over to you and have a great workshop.
Great, thanks, Delphine. I'm just loading up my slides here, so hopefully everyone can see those now. That's great.
You can see.
Fantastic. So hello, everyone, and Delphine, thanks for the introduction, and UCAN for inviting us here today. My name is Myron Millia-Dare. I'm a corporate lawyer with a focus on the technology sector. I advise a lot of clients with various aspects of corporate law, focusing a lot on cross-border transactions. So it's glad to be here today. So the focus of our presentation is really on e-commerce in Canada. And what we're focusing on today is for European companies who are looking to do business in Canada through e-commerce platforms. So what we'll be covering today is a review of CETA's Article 16, which speaks directly to e-commerce. We'll be looking at some jurisdictional issues of doing business in Canada for European companies. We'll look at the privacy laws, some issues relating to electronic signatures, and also registering domain names in Canada. We'll take a brief look at the online consumer protection laws, which relate to the sale of goods in Canada, and anti-spam legislation. Now, while we're going over these subjects, these aren't a comprehensive list of issues that will face companies, but it will give you some of the key considerations to keep in mind when doing business in Canada for European companies. So first up, we'll have a look at what e-commerce is. So what we're talking about here is the sale of goods or services through electronic platforms or through the internet. So there's no physical brick and mortar stores. It's all conducted and transacted online, whether through websites or via email. Due to COVID, we've seen a drastic shift to how businesses and their customers interact and transact. And this is a global trend too that we've seen, where we're moving away from brick and mortar stores and moving towards transacting online. We've seen traditional businesses move in this direction, and we expect the trend to continue. Although we've seen slowdowns in certain economies and certain areas, e-commerce continues to have go from strength to strength and continues to be a bright spot in transactions and trade. Now, for anyone who doesn't know, CETA, or the Canada-European Comprehensive and Economic and Trade Agreement, remains one of the most significant and consequential bilateral trade agreements globally, and it sets standards for trade of goods and services and reducing non-tariff barriers. It's really made it easier to export goods and services between EU and Canada, and really provides legal certainty for organizations who are looking to transact. Article 16 itself of CETA, which focuses on e-commerce, which will be the subject of today's talk, really recognizes the importance of e-commerce in transactions and the shift away from your more traditional brick and mortar stores and other forms of transacting. And it really recognizes the need to promote international cooperation in this area. So it's really two parts to Article 16 that we'll be focusing on. So Article 16.3 in itself provides that signatory states really are one of those areas that need to focus on what we call electronic deliveries. So this is computer programs, text videos, and other deliveries that are digitally encoded. So the concept here is that the signatory states should not be imposing customs, duties, fees, or charges on those electronic deliveries to allow for a balanced trade and free trade between these entities in there. The second part of Article 16 focuses on the data privacy considerations. So for this, it's an understanding that signatory states need to recognize the importance of interoperability between regulatory frameworks, where you have, for example, different rules between the two, and finding a way for those to coexist, but also protect individuals who are engaged in e-commerce. We've continued to see a push for protections of individuals, and data privacy continues to be a key issue. So it's an understanding of those protections. So that's really a summary of what Article 16 covers. And now we'll go into some of the considerations European companies should be aware of when attempting to enter the Canadian market. So we'll start off with a bit of an overview of the legal landscape in Canada. So Canada is a federal state in itself, where legislative authority is really divided between the federal government and the provincial governments as well. Canada has 10 provinces and 3 territories, each with its own provincial government, and with those its own independent rules. So the importance of this is that for e-commerce, the majority of laws applicable to e-commerce are found within the provincial legislation. These typically relate to, as you'll see on the slide here, consumer protection laws and contract laws. So the foundations of what laws apply. In addition, when operating a business, you have employment laws, you have requirements to register extra provincially, which we'll get into. These are all at the provincial level also. So it's being aware of those. In addition, there are federal laws which are critical to the trade of e-commerce, so those cannot be discredited, and these include intellectual property, competition law, anti-spam law as well. And then there's a hybrid where we have privacy laws, which fall within the jurisdiction of both the province and the federal government, and we'll get more into those as we go in. The key point here to remember, and the key takeaway here is that each province has its own jurisdiction. So being aware of which provinces you sell into is critical at this stage, because the laws of Ontario differ from the laws of BC and differ from Quebec. Now, there are some comparisons, but there are some unique differences. So organizations looking to enter the Canadian market really do need to be aware of where their significant customer base is, and ensure that their operations really are tailored to the laws in those jurisdictions. So next, we'll move on to some of the jurisdictional issues where we'll be discussing here. So a question we often get is really, do Canadian laws apply? If a company is selling 1 or 2 goods to Canadian citizens, is that really a concern? Should they be aware of it? Is there a threshold here? So one of the rules we look at when we're talking about internet-based transactions is we're looking for some relevant factors, which is useful in determining jurisdiction. It's a bit different from, as you can imagine, a physical brick and mortar store where you have a physical presence within Canada. E-commerce tends to be a bit different. So you're really looking at certain factors outside of just the location of the store as well. So in this mind, you're looking at the domicile or residence of both the seller and the purchaser. You look at where the contract is formed, and you also look at where equipment is used to provide services. So how significant are the operations within Canada. Now, in saying that, in the context of e-commerce, Canadian courts will generally have jurisdiction where the forum is, or where the place of transmission or the place of reception of the online contract is formed. So when you have an individual within Canada who's a resident, particularly in the consumer context, when you have an individual here, there is an obvious connection to Canada with that individual. So Canadian courts will have typically jurisdiction in those instances. Now, some other jurisdictional considerations that go really beyond the scope of this presentation, because they are more on a company by company basis, is the requirement to potentially register extra provincially. So if a company does business within a certain province and that definition of business is defined, and there's threshold discussions here, there is a requirement that an organization register extra provincially in each province in which it does business in. So for that there, it's advisable to speak to a professional who can look at your individual case and have that discussion with you, but we are flagging that here. And then the other jurisdictional question becomes does it make sense for you to set up a Canadian subsidiary? We advise European and companies from multiple markets with this in mind, where you've got to look at really your operations, or if you have employees, the tax benefits from registering a subsidiary in Canada, and all of those play into that. But that's really a decision based on the company, and it's very subjective to that organization. So that's beyond the scope of it, but we are flagging that today. So one of the bigger pieces here that we'll discuss is privacy laws. Now, this is a critical piece for e-commerce companies. And this is really growing from two aspects. It's one, e-commerce companies tend to collect and utilize significant amounts of personal information about the individual, more so than when you're operating a brick and mortar store. You're collecting very important information about the individual. You're collecting sensitive information about payment information, individuals' names, addresses. You're collecting information about the individual's system and operating system that they're accessing your services from. So there's a significant amount of data being used here, and organizations are typically using that information for other purposes. So they'll look to use it for targeted advertising campaigns, and maybe look for other ways to generate revenue from that. So it's critical to understand what laws apply. So in Canada, there are both federal and provincial laws that govern the collection, use, and disclosure of personal information. And each one is slightly different. So the basis of it is PIPEDA, or the Personal Information Protection and Electronic Documents Act, which is a federal piece of legislation, governs unless there's a province has enacted laws that are substantially similar to PIPEDA. And those provinces right now are Alberta, British Columbia, and Quebec. So in those three jurisdictions, the provincial law is the law that is applicable. In every other province, including Ontario and New Brunswick, Nova Scotia, it is the federal PIPEDA which governs too. So looking at PIPEDA, it governs how all private sector entities are allowed to collect, use, and disclose personal information in the course of commercial activities. So the definition of personal information is quite broad. It's information about an identifiable individual, but does not include business names, title, and telephone numbers. So the definition is intentionally broad to continue to capture new forms of personal information as they're deemed to be personal information. And we can think about those changes over the years from biometrics to and other forms that have taken place. So generally, PIPEDA requires organizations to notify and receive consent from individuals before collecting personal information. That's a critical piece, so organizations need to be aware of these requirements and how to fulfill them, and that's really understanding how they collect the information and ensuring that privacy policies are provided to individuals so they're aware of it. There are specific consent requirements, and it's ensuring that you're collecting the information in that consent. Now, CETA doesn't restrict the transfer of information abroad, but there are some disclosure requirements when doing so to the individual, and there's also the requirement that oversight is still as required under CETA. So you can't circumvent your obligations by sending it to abroad, but there's no prohibition on it. As with the GDPR, in the EU GDPR, there is data breach reporting requirements. These are really when there's a data breach and there's a real risk of significant harm to the individual, that those requirements are required. So moving on to some changes that are proposed, we wanted to flag for you. So while we've just ran over CETA, there is a potential that these privacy laws will change. The federal government in November 2020 introduced what's called B11, which is the Digital Charter Implementation Act, which had its first reading in November 2020, which is really looking to modernize Canadian privacy laws. It's going to significantly increase protections to Canadians' personal information and really give Canadians more control and greater transparency when companies handle their personal information. It's really going to be sweeping changes, and you can think of it in a lot of ways to imputing principles under the GDPR. So this is really the right to data portability, the right to be forgotten, the right to object to automatic processing. So it's really going to create a lot of changes to how organizations must operate in Canada when dealing with Canadians' personal information. And it's also going to create significant fines and penalties, where it's penalties up to 10 million or greater, 3% of the organization's annual gross global revenue for failures to comply with certain requirements. So you can see that it does have teeth. Now moving on to electronic signatures. This is really a good point here for a discussion. In Canada, these are required in certain instances for the requirement for wet ink. This is really, we're moving away from it. There's only very specific requirements where wet ink's required. In Canada, generally, you are able to rely on e-signatures. We'll switch to here to talk about where those requirements are. The exceptions to the electronic signatures being allowed really are in wills, power of attorneys, negotiable instruments, and trusts too. The one thing that is typically a bit different than that is there are requirements of certain lenders as well, so banks in Canada, where they will require your traditional wet ink. And these are more internal processes and procedures, so it's always recommended to check with them. But generally speaking, in Canada, there is an acceptance of e-signatures for the majority of corporate documents, and they essentially have the same legal enforceability as your traditional wet ink signatures, and also have the requirements that you'll typically see for traditional signatures and traditional contracts, where you do require your offer acceptance and consideration, but the treatment is identical to that of a traditional paper and wet ink signature. So we'll move on to registering a Canadian domain. There's reasons to do that. You get the show that you're in Canada, you're really operating your business in Canada and have made a conscious effort to do so. Some companies rely on a .com name, but some others will look for a .ca registry. Generally speaking, registrations are managed by the Canadian Internet Registration Authority, but you can, as in other jurisdictions, purchase domains from registrars or resellers, and that's typically what is done. So the requirements to purchase a Canadian domain, there are some Canadian presence requirements. So this is, you have to either be a Canadian citizen, you have to be a corporation under the laws of Canada, a partnership, unincorporated, or the owner of a trademark but only to the extent the Canadian domain consists of exact wording of the registered trademark. So that last one tends to be the requirement that European companies and international companies will rely on. So if you have a trademark name, you can then get, as long as it's available, you can get the domain name that's associated with that trademark itself as it's written. So you can't add words to it. It can't be just a brand name you use. It has to be a registered trademark in another jurisdiction. Now, what happens if you go to register and you discover that somebody is using your trademark? So we do have a domain name dispute resolution process in Canada, which is operated by CETA, and it really provides a forum for parties to enter into a complaint and file a complaint when there is an individual who is essentially cyber squatting on your domain name. Now, there is a very specific set of requirements that must be proven to be able to be successful in this domain, and we'll look at those now. And these really are, it's a three-prong test. So the first prong is that the registration has to be confusingly similar with a mark to which the complainant has rights to. So it has to be a mark where it's registered or unregistered, but it has to have a use within another jurisdiction. So if you're doing business and you're looking to do business in Canada and you have a trademark that is covering certain wares and you notice someone else is using it, you having that registration will help fulfill this first test. Now, the second one is that that party, so the proposed offending party, has no legitimate interest to that domain name. So if you have a registration in Europe and you notice that there's a domain name registered to an individual in Canada, and that individual is selling products that relate to that domain name, and they're not infringing on your mark, then you're able to then be able to, you won't be successful in that claim. There has to have no legitimate interest, and you're really looking at somebody who's cyber squatting here. Now, the third one is that has to be proven is that the registrant registered in bad faith. So it's not enough that they just don't have a legitimate interest. You have to be able to establish on a balance of probabilities that they registered in bad faith. And essentially, to be successful through this dispute resolution process, you have to prove all three prongs on a balance of probabilities. So that's really the process there for dispute resolution. Now, moving on to consumer protection laws in Canada. This is again registered and compliant with the province in which you're selling products in. So if you sell in Ontario, you have to comply with Ontario laws. If you sell in BC, BC laws, and so on. And if you're selling in multiple jurisdictions, you have to be aware of each jurisdiction's consumer protection laws. So these only apply to consumer transactions, so it wouldn't apply to B2B sales. This is B2C. But if you're in the B2C market, you do need to be aware of these rules too. So in Ontario, we'll start with Ontario. There's specific obligations on the part of the supplier for consumer agreements formed by text-based internet communications in which the consumer's total payment is greater than $50 Canadian. If you're selling services, it's not just a monthly fee, so you can say, oh, my SaaS service, I only charge $10 a month. There are some aggregation in the calculation of that amount, so you do need to be aware of that too. Essentially, once you meet that threshold, then the supplier must provide certain prescribed information to the individual. So it's really an exercise of looking at your consumer contract and materials you're providing and ensuring you're meeting those disclosure requirements. This can include the name of the business, total cost of the goods, and clear and apparent terms of the agreement too. So there's a number of requirements that would need to be reviewed, and they're dependent on the services you're providing or the goods selling. So it's really an exercise to confirm you're meeting those requirements. In addition, under consumer protection laws, there's requirements for true and accurate disclosure and a prohibition on the disclosure of false information relating to the products. This is a critical piece here because there can be fines and the ability for the individual to repudiate or cancel the contract and demand a full refund if that false information is being provided. Some examples here of false and misleading information can be claiming that the product will be delivered by a specified time, claiming that the service, part or replacement or repair is needed or is advisable when it's not. So it's broader than just saying this product will perform X and it not doing so. There's a number of different categories that organizations and individuals need to be aware of when selling to consumers. And as discussed, the remedy here is that a consumer can withdraw from the contract within 1 year and get a full refund. So you can understand that the risk here of not ensuring your contracts are up to snuff and your processes are in place is significant. Flagging here as well that if we go to Quebec, there are some language requirements too as well for organizations. Businesses need to ensure that their standard form printed contracts must be written in French, and their signages as well. So there are some specific requirements going into Quebec with the French language rights too. So organizations selling in that province do need to be aware. Now, the final point we'll discuss today is Canada's anti-spam legislation. So everyone knows Canada's anti-spam legislation, or CASL, is one of the most prescriptive anti-spam laws in the world. CASL regulates the communication of unsolicited commercial electronic communications sent by entities to individuals, as well as the unsolicited installation of software on computers. Non-compliance with CASL can lead to significant monetary penalties and criminal charges for non-compliance. Thus, it's absolutely critical that organizations ensure they send any commercial electronic messages in compliance with CASL. Now, CASL applies to CEMs that are either accessed in Canada or sent from a device within Canada. Businesses also should be aware that there are liability for actions of third-party providers engaged by that business who send CEMs on their behalf. So the reality is if you're engaging a third-party provider to do your advertising campaign to Canadians, you need to ensure that that company meets its obligations under CASL when it's sending CEMs on your behalf. Failure to do so will incur fines and penalties and also investigations by regulators if it's found to be in contravention of that. It's not enough to say, well, we outsource this. So being aware of that as well is critical. So what is CASL? Well, CASL prohibits the sending of CEMs without prior consent and only permits them if certain formal requirements are met. Now, there is implied consent in certain instances, but this is a very limited number of instances when there's typically already an existing business relationship. So a customer has either purchased goods or inquired about goods, and these are all time limited. So what's typically required and what's typically done is where an individual will actually get really explicit consent from the individuals through a CASL sign-up mechanism for that consent. Now, if you're opting in, that express consent, there are form requirements even in that consent itself. So ensuring that the organization meets those form requirements is critical. Otherwise, all of the consents you collect may be deemed to be useless. So it's really one of those things where there's also form requirements for how the CEM is sent, requirements for disclosure of information within that form, and also requirements for how the individual can unsubscribe. So It's typically done where an organization getting into this will either engage a party who can provide meaningful advice about how the process is, what the requirements are, and ensure that their processes meet those requirements. Failure to do so, there's significant fines. There's a maximum administration penalty for individuals of 1 million, for organizations 10 million, and directors and officers of the business can even be found to be personally liable for violations. So it's very important that businesses do take into consideration these requirements and take steps to meet them. So that's my part today. I know there was a lot we covered. Please do send us questions during this presentation. We'll allow time at the end, and there will be a paper being distributed by the UCAN, which will cover a lot of the topics now that we've spoken about today. I will now hand off the presentation to my colleagues, Peter and Eugene, who will cover some of the critical intellectual property issues that relate to e-commerce.
Thank you, Myron. Can everyone hear me? My name is Eugene Garchuk, and I will be presenting 7 slides on intellectual property. Now, intellectual property, you'll see from the first slide, includes a number of aspects such as trademarks, patents, copyrights, industrial designs, and trade secrets, and we'll be touching on each of those during our presentation. And the reason why IP has been added to e-commerce is because intellectual property underpins or allows a legal way to protect innovations in e-commerce transactions. So the theme that I want to leave behind after our presentation is that the intellectual property regime in Europe is very similar to that in Canada. So it's very easy to protect your intellectual property going both ways, Canada to Europe and Europe to Canada. Starting with patents. Patent protection lasts 20 years in both Europe and Canada. There is a 1-year priority in both Canada and Europe. And what that one priority means is that if, for example, you file a patent application in Europe or one of the European countries such as France, then by international treaty, if you file a corresponding patent application in Canada within 1 year, it is deemed that the filing date in Canada will be the same as the filing date in Europe or France. And the reason for that is it takes time for some companies to decide whether or not they want to protect their inventions overseas. Now, the requirements for patentability in both Canada and Europe are very similar. They require 3 things. First, in both Europe and Canada, you need the element of novelty. And what novelty means is that whatever your invention is, it's new. No one else has done it like that before. But not everything that is new is subject to patent protection. So you also need the element of unobviousness. And the best way of looking at unobviousness is to say, what is different about what I'm doing compared to all the prior art that's gone before? And finally, your invention has to be useful. That's a low threshold. What that means is your invention does what you say it does. So moving on to slide 3, in Europe, a patent application can be filed under 3 mechanisms. First one is you can file a national patent application in individual countries in Europe. So for example, you can file a German patent application just in Germany. Or in Europe, you can file a regional patent application, such as a European patent application, where you can designate some or all of the European member states, and there's approximately 40 of them. And finally, you could file from Europe an international patent application. These are known as PCT applications, and you can designate individual countries in Europe, or you can file a European regional patent application and other foreign countries, which include Canada. Now, when we move on to Canada from that side, in the next slide, Canada, however, only has 2 mechanisms to file patent applications. One, you file directly in the Canadian Patent Office, or again, you can file this international patent application in Canada, designating either individual countries in Europe or other foreign countries, including Canada, or you can file a regional European patent application in the PCT application, again, covering Canada. So, and there are certain time limits. You've got 30 months within which to decide what countries to continue in, and that gives companies either in Europe or Canada a time limit to decide how long and what countries they want to continue in. So now looking at slide number 5, there is a 1-year grace period in Canada from the date of public disclosure. What that means is if you've disclosed your invention to the public, either by publishing it in a paper or talking to someone about it, you have a 1-year grace period within which to file a valid patent application. Now, Europe, like most other regions of the world, have no grace period, and it requires absolute novelty, which means that you must file a patent application somewhere within which to preserve your rights. Now, in the next slide, Europe has something a little bit different than Canada has. So there, in Germany and Austria, there's a concept called the Gebrauchsmuster. Hopefully I'm pronouncing it correctly. And this is known as either a German utility model or Austrian utility model. These are patent-like intellectual property protecting inventions, but it's slightly different from a normal patent because these utility models, you can processes and methods cannot be protected, only products, and the term of these utility models are 10 years and not 20. So if you happen to have a utility model in Germany and Austria, you can still file to protect that concept in Canada, but you would file it under the guise of a patent application or an industrial design, which I mention on my next slide. So moving to slide 7, industrial designs. These, well, patents protect inventions in products, methods, and processes. In other words, a patent protects how something works. Industrial designs protect how something looks. So in Canada and Europe, you can protect shapes and patterns by design applications. An example of an industrial design would be the shape of a grill of a Rolls-Royce, the shape of a Perrier bottle. You can't patent the bottle, but you can patent the shape of a Perrier bottle by an industrial design. Next, in both Canada and Europe, you can protect new plant varieties, such as, for example, a grapple. A grapple is a cross between a grape and an apple, and these can be protected in both regions. And then my final slide, I want to touch on trademarks. Again, in keeping with my theme, trademark law in Canada and Europe are similar, and they're easy to protect in both areas. In each case, trademark is registered in association with goods and services which are classified in accordance with an international scheme known as a NICE classification. So in Canada and Europe, a registered trademark has a term of 10 years, which can be renewable indefinitely for further 10-year periods upon payment of a renewal fee. Again, for trademarks, Canada and Europe has a 6-month priority period, not the 1 year as in the patents, where if you file a corresponding trademark application within 6 months in the other country, the effective date of filing is the same as in the first country. And my final point is that in both Canada and Europe, you can register words such as Philips for electronics, or logos such as Just Do It for Nike shoes, or you can register scents. An example of this would be the sweetish, fruity, doughy scent of Play-Doh. You can also register colors. So for example, the particular blue for Tiffany, so long as these trademarks are not confusingly similar to other trademarks. And again, I want to end with just a general concept that it's relatively easy to protect your intellectual property in Canada, and the laws are very similar. So now I hand this over to Peter Little, my colleague, to talk about other aspects of intellectual property.
Thanks so much, Eugene. Yes, my name is Peter. I'm going to be continuing to talk about some of the concerns about intellectual property and other issues around intellectual property that you should be aware of if you're planning on operating an e-commerce business with some connection to Canada. So the first thing I want to talk about is something called the Madrid Protocol. Now, the Madrid Protocol is essentially an international filing system for trademarks. Its main selling point is that it allows applicants to apply for trademark protection in more than 100 countries through the filing of a single application in a single language. So essentially, if you're in a country that's a member to the Madrid Protocol and you're an eligible person, you're able to file a trademark registration and designate in that trademark application, the countries where you wish to seek trademark protection. And the World Intellectual Property Office will then distribute that trademark application to those countries, and you may be able to get your trademark registered in those countries. Now, up until recently, Canada was not part of the Madrid Protocol. We were actually quite late to join the party. But we did recently update our trademark laws, and we have since acceded to the Madrid Protocol. So what that means is that if you are filing a Madrid Protocol application, you are now able to designate Canada as one of the countries in which you are seeking trademark registration. So this basically just makes it much easier for international applicants to get trademark registrations in Canada. Now, if we flip over to our next slide here, you may be wondering, if I operate an e-commerce business and my presence in Canada is mainly digital, is there really any point in seeking out trademark protection? And the answer to that is yes, in some certain situations, it is still practicable. Let's say you operate a business that offers some service over the intranet that's available to Canadian customers. And with that service, you don't have a brick and mortar location in Canada. You're not really sending any actual physical goods to Canada. You don't really have any other physical connection to Canada. Well, if you are able to digitally display your trademark over the internet in association with the services that you're offering, and those services are considered to be performed in Canada, then you may be able to hold a trademark registration. But the key there is that you are actually using your trademark in Canada. Use of a trademark in Canada is absolutely essential. Really, the saying is you use it or you lose it, because holding a trademark registration in Canada without using it will just have it get expunged if challenged. Now, it can be a bit confusing as to what use actually is, so I've included an example here. So Hilton Hotel held the Waldorf Astoria trademark registration in Canada, and they held that in association with hotel services. So for those that may not be familiar, Waldorf Astoria is a brand of luxury hotels, and they have hotels in multiple countries around the world. But the issue here was that they didn't have one of those hotels in Canada. There was no brick and mortar hotel in Canada. What was offered to Canadian consumers was the ability to book, reserve hotel rooms in different Waldorf Astoria hotels in other countries. And that trademark, Waldorf Astoria, was present on the website and in emails confirming reservations. And recently, the Canadian Federal Court of Appeal held that this was sufficient use of their trademark in Canada, despite not having an actual hotel in Canada, because Canadians were getting some sort of benefit, even though it was just through digital means. So if there is a sufficient degree of interactivity between the trademark owner and Canadian consumer, there can, that amounts to use of that trademark in Canada with those services over the internet. In those situations, you may be able to get a trademark registration and hold it. Of course, it's important to point out that it always goes on a case-by-case basis. Not every trademark holder is going to enjoy the same enjoyment that Hilton Hotels did with their Waldorf Astoria trademark. But I do mention this because it may then be useful if you're thinking about whether or not to get a trademark registration, to speak to a Canadian trademark agent and see if this is something that can be held. Now, flipping to our next slide, I'm going to talk a little bit about copyright. I always feel that copyright is one of the heads of intellectual property that people seem to have the most familiarity with. In Canada, copyright protects original literary, dramatic, musical, and artistic works. And people can, commonly understand this to mean that copyright's going to protect your video, a document you've drafted, a painting. So people seem to have a general understanding of copyright. What is important to note about copyright is that it does arise automatically with the creation of a work. So it's possible to register your copyright in Canada with the government, but to hold protection of a copyrighted work, it's not necessary. It'll arise automatically with the creation of that work. And so the owner of copyright is the person that has the sole right to produce or reproduce the work or any substantial part thereof in any material form, whatever. And that is basically just legalese to say that if you own the copyright, you're able to control its distribution, its reproduction, and how it's basically dealt with. And copyright is a very important consideration for e-commerce. Again, if you're operating mostly digital, a lot of what you're presenting over the internet or digitally may be protectable by copyright. For instance, if what you're selling is a digital asset like a video, copyright is going to be important to protect that video. But even if you aren't really providing digital assets for sale, other elements of your online presence, your website, your videos, logos that you may use in advertising, those are works that may be protectable by copyright. So it's important to know that you may have rights in those if you are the owner of the copyright. And I mentioned this, specifically copyright in Canada, because copyright in Canada is not just available to Canadian citizens. Copyright in Canada extends to citizens of treaty countries. And what treaty countries are, and it can be a bit technical, but it's basically countries that are party to certain international copyright agreements, including things like the Berne Convention. So certain persons in Europe, a part of European countries, if they've authored an original work, even though they're not a Canadian citizen, and even though they may not have been in Canada when they authored that work, they may be able to claim copyright protection in Canada if they are part of a treaty country, a citizen of a treaty country. I'm flipping to my final slide here. This is just to bring it full circle with what my colleague Myron started with, just speaking of CETA. In the interest of time, I'm not going to go through this extensively, but just to be aware that CETA also contains a number of articles directed at various intellectual property rights. I've included on this slide a couple of examples of articles directed towards copyright. Of note, on the third one, CETA addresses the prevention of unauthorized camcording of presentations of films. There's other articles of CETA that are just directed toward general protection of intellectual property right, ensuring that the member parties are ensuring that their court jurisdictions have the ability to do a variety of things, such as issue orders to prevent infringing goods from entering channels of trade. But really the main takeaway is that by being a party to CETA, Canada and the European Union are able to provide a little bit of assurance to each other and businesses within those countries that the other countries, such as a European business doing business in Canada, they can rest assured that Canada has sufficient protection for intellectual property rights. And I will end my presentation there and turn it back over to Delphine.
Great, thank you very much to the three of you. Before we actually go into the question and answer, what I will do is that I will, just give me a few seconds, but I will call Paul and David from Arco Info. The target here is that we actually wanted to give an opportunity to a European company which developed here in Canada to actually share their experience in that field. So I will give the floor to Paul and David. They don't have a presentation, really, it's just about sharing experience. So let me just bring Paul over.
Yeah, you're not getting me on.
Yes, you can. Yes, great. So yeah, the target, Paul, is like in 5 minutes, in a few minutes, if you can introduce yourself, your company, and why you choose Canada, and what was your experience in setting up the company in Canada, mostly towards CETA and the Chapter 16 and the digital world in Canada.
So basically a digital mail company. And it's a very strange word to say. We started our company in the document management, so full text search retrieval. And over the years, we moved to capturing the data from somebody who wants to send it to somebody in a digital way and delivering it to the other party in the way he needs to receive it. And basically our business started in Canada because of the language. We had Hydro-Quebec who had an issue with some La Grande Baleine, so many people might know that. And they needed a software that worked in both English and French. Of course, there were many technical questions around that software, but we managed to solve that. So then we came across, and now when we fly across, like today, we do Teams or we do Zoom or whatever. But then when we came across, we literally took a portable PC, and portable I meant by one we could lift up, put on the plane and bring on the other side. So it was not a portable as we call it today. And after we presented everything, they decided to go along with us. There's a nice anecdote because we didn't know the law in Canada. So one of my colleagues who came across arrived in Montreal and he said, I'm coming to work here. So they took him aside. He had to pay $8 per day he was in Canada. So we said we came to visit some friends and we were just going through. So, but since then, we had, yeah, for me, Canada, or for us, Canada is much like Europe. So culturally, it's much the same. Business-wise, people think the same way. They, maybe Belgians won't like to hear that, but there are other people around the world who think in the same way. So it's for us, we don't need to adapt mentally to be able to do business in Canada. The laws are different, it's true, because in Belgium, when you start a company, the first thing you think is I need an accountant. When you come to Canada, you think I need a lawyer, which Dave learned me. So he said, oh, here first you get a lawyer and then you get an accountant. We usually get first an accountant and we only get a lawyer when we have problems. So Canada, and I'm not saying you need problems to have things going, but it's different. So same in the States, it's even worse there. So the first thing you do is make sure you have the right lawyers. But it's something you need to adapt. So when they ask me what's the biggest adaptation for Arco doing business in that territory, it's not the people, it's the people think alike. They speak a bit French, a bit different. Québécois is Québécois. So that's not the issue. But when it comes to business, it's like I heard in the previous presentations, it's in Ottawa, you have other law rules than in Quebec, and then you go to Vancouver. So in Belgium, there's one law. In Canada, apart, wherever province you operate, the laws are a bit different. And you need a good lawyer, you need a lawyer to help you manage those things. That's for me, that's for us, that was the biggest change. For the rest, Dave, I think it's maybe you can help on the IPs. So on IP side, like I heard in the previous presentation, it's very similar to Europe. We're pretty well protected. So the CETA gave us, for Arco, for us, we're not producing products. So we just deliver software. So CETA is not that difficult for us, but it does open. We had a lot of attention in Belgium because of the CETA, because we were requested to present at many events. And we were even in, I think it was in Calgary, Dave, we were presenting. Yep. We were just asked our opinion, and I'm a liberal thinking person. Liberal doesn't mean I'm for one or the other party, but I think economy is priority number one, and the rules must help economy to evolve and protect people from doing damage to the others. And I think in previous presentations, if somebody had a great product, everything should be protected to make sure his rights are protected. And I think in that sense, Canada for me is a democratic state and helps us in doing that properly like we do it here. So that's a bit my view. I also think that organizations like yours is crucial because you need when we said you need to think global and act local. So if we are successful in Canada, it's because we work with the people there and we talk to each other and we work together. And we managed to secure a large deal last year, but that's because we went to receptions, we went to contacts, and they said, oh, we have a problem. Yeah, can you solve it? Yeah, we can solve it. And then they checked and we solved it, and come along. And so people work with people. Our business is a B2B contact. And I think I'm very proud I can be here tonight. So tonight, for us, it's tonight, so sorry. Yeah. And by the way, my soccer team is leading, so it's good.
David, do you want to add one or two comments briefly on the maybe IP or anything?
Yeah, I think that thank you for the opportunity to chat with everybody here today. But I think that Paul touched on a couple of things that I can expand on with regards to the preparation is really critical. And there's, in my mind, there's two ways to come into a new market. It's the pull, or you decide to push in. So the pull is you get the big customer and you have to make a decision about, is this worth the expenditure of resources and so forth. But when it's something that you're making a plan to come into, you just cannot plan enough. And one of the things that I think is really helpful is to make contact with your country-specific chamber. In this case, with UCAN, you have access to so much knowledge of people on the ground in Canada. And you have to work that. You have to approach these people and talk to them and get references and those things. But that's a really critical step to help you to understand what's the best way to go. I think the other thing is when you have, we're an OEM software company, but we also use integrations. So pretty important to make sure that you're able to serve those from a distance. In the case of us, we set up as an Ontario corporation, and that helps a lot to be able to make your presence felt in the local areas and your ability to step out from there. But you don't always need to do that either. As far as, you can actually get things going, working with local people, working with contractors and so forth. So be flexible on the model that you come in with, depending on your needs. And the last thing I would just throw in, lots of things I could say, but one of the comments related to the patents, novelty is a very subjective thing. And I think that you have to be aware of the patent process. So if you have something that you want to protect from a trademark perspective, that's something that I think is allows you to keep a certain amount of your intellectual property private. But if we go for patents, you have to basically show why. And so sometimes you have to decide, is it better? I had a story from a very large company one time that I was forcing to sign an agreement related to patent protection. And the guy kind of chuckled and he said, we have a lot of lawyers on staff. So if we decide that we're going to co-opt this, we're just going to do it, and then we'll see you in court. Now, that's not very Canadian, but it is a reality. So the idea of exposing everything that you're doing in a patent application, I may be wrong with deference to my colleagues from Miller Thomson, but you have to make a decision about that. Is it really going to be worth it? Or do you come in with the idea that you build your brand, build your product, and then look for licensing? Because most companies aren't looking to get into a legal battle with you, but maybe there's ways to offer your product that can be done through licensing that avoids all that. And then you don't have to worry about somebody coming in and copying your technology. So that's all I have for now, but Thank you very much.
Thank you very much, Paul and and David. Now I'm calling my colleagues from Miller Thomson to come back in so we can go to the question and answer session. So the first question is, what do international standards regarding data privacy mean, given that data privacy regulations are different between the EU with the GDPR and Canada? Can those standards evolve with the coming data privacy law in Canada? I guess that would be Myron. Oh, we cannot hear you and you are not muted.
Is that, can you hear me now?
Great, yeah.
Great technical issues. They always happen at some point. So this was the time. So essentially that's a really good question. So the idea here is, and you can kind of track this is these changes are coming about because the world as a whole is taking steps to react to the importance and sensitivity to not only use of personal information, but the multiple manners in which we are using it. So there is going to be a convergence of, or at least I'm seeing it, of what you're seeing with the GDPR that came out and set the new standard around the world. You saw California reacting to it as well. And now you're seeing Canada taking a similar step where there's just an understanding that at least in Western countries, there needs to be some convergence of these principles and an importance to reflect protection of personal information of individuals too. So it's a great question, and it's exactly what we're seeing now. And if you look at the principles, or at least of the first reading of the legislation, it has a lot of similarities with the GDPR. So good question.
Great. We have another question. Could you tell us what examples of CEM would emails be included? I think it's again for you.
Yeah, no, exactly. So really for a CEM, it's a commercial electronic message. So it's any message which has an aspect or an element of a commercial conversation or commercial message in there. So are you advertising a product? Are you advertising a service? Are you talking about a promotion that's coming up? Are you talking about a marketing campaign? It's any of those things. And it's even more complex than that, because it can be only one element of the email itself. So you could be sending a message just giving someone their user credentials to log in to their account with you. If you have at the bottom, hey, listen, we're launching product ABC, or if you sign up for an annual subscription, you'll get 25% off. Those items, those can then turn the message into a CEM. So it's being aware of those aspects too. And it's, we rushed through a lot of the concepts here, and this was really to give you a flavor of it. The workshop paper that's being distributed will give a bit more, but even then it's a good idea to connect with somebody who can talk you through these principles, because it's very regimented, and it's really easy to trip up of the requirements. So it's good to have those conversations.
Great, thank you. And I will take one last question, because I want to be mindful of everybody's time. What action should we take to comply with anti-spam when we contact Canadian companies to propose products to be imported in Canada?
So with that instance, it's really going to be depending on who you're communicating with, so who your customers are. If you're talking to a supplier, that's a different conversation too. But essentially, there are form requirements that are required under CASL for the CEM. If it's B2B, there are other exemptions too, but it really depends on who you're communicating with. But it's really having an understanding of essentially the form requirements for the email, the consent requirements, sign up, and then the unsubscribe requirements of the process too. And I know we are running out of time, so I'll wrap up my response there, but please do feel free to reach out. We can discuss these further offline. I know a lot of the concepts that have been brought up today will spark other thoughts or questions, and we welcome those questions as well. So.
Yes, indeed. Thank you very much, Myron. All the questions were for you, but I'm sure there's other questions. So feel free to send your question to info inbox, so info@ucan.com, and we will put you in contact with the Miller Thomson team or even Arco Info if you have some questions for them. Again, just as I said earlier, the paper will be published by end of the week or beginning of next week. So feel free to register to our newsletter on our website. And officially, I would like to thank all our panelists of today and Miller Thomson team, because they did a great job in helping us understanding what is Chapter 16 of CETA, because sometimes we see CETA, but we need to understand how companies can use it, whether these European companies or Canadian companies. And I would like also to thank Paul and David to share their experience. Again, thank you very much to everyone. Feel free to contact UCAN for any questions. And I will see you for another workshop or another webinar coming soon. Thank you very much, everyone. Have a great day or a great evening.